My name is Brittany Forrester. I'm a senior associate here with Tully Rinckey. I've been practicing security clearance law for several years now. I've handled cases at all phases, from filling out the SF-86 form or the 85P, depending on what level of clearance you're applying for, all the way through responding to letters of interrogatories, statements of reasons, all the way through clearance denials that result in either a hearing and then further to an appeal. So I have lots of knowledge, and today we're going to be covering one of the 13 guidelines that the agencies can use to disqualify an individual and/or revoke an existing individual's clearance. So the concern around Guideline E, and Taylor, if you want to take us on to the next slide, and Pat, the first one, there we go. The concern around Guideline E is conduct involving questionable judgment, lack of candor, dishonesty, or an unwillingness to comply with rules and regulations, which then raises questions about an individual's reliability, trustworthiness, and ability to protect classified or sensitive information. This is, and you'll hear me say this throughout this presentation, this is probably the most popular guideline that I see on a letter of interrogatory or a statement of reasons, because it can be applied in many different situations, regardless if it is something that is involving something that they believe to be questionable judgment or lack of candor or an unwillingness to that are very prominent regarding Guideline E. And that is, as you see on the screen here, it involves lack of candor, refusal or failure to cooperate with the security processing. And you can imagine this is quite a vast section that the government looks at to review someone for clearance eligibility. Essentially, refusing to cooperate could go anywhere from refusing to participate in an interview, refusing to provide a medical release if they ask. That comes up a lot if you have to report that you've had past psychological conditions that fall under the purview of the SF-86 reporting. And also polygraph. And a lot of these issues from Guideline E result from polygraph exams, in the sense that if you ever fill out the SF-86 and misrepresent or omit or conceal or don't quite tell the entire truth on the SF-86, the number one way that the government will find out about it if you progress in your career is through a polygraph exam. And you're refusing to either cooperate with the polygraph and/or having an unfavorable determination from a polygraph can definitely lead into a Guideline E statement of reason allegation. The second option there is refusal to provide full, frank, and truthful answers. So they go hand in hand. When you're completing the SF-86 and all of the interview questions with the investigators, you want to be as open, honest, and forthcoming as possible. That way, there's no possible way they find any discrepancies between what you've reported on the SF-86, what your past supervisors may discuss regarding your past employment, what individuals you put on there as references may discuss as your conduct, specifically related to drug use, alcohol use, any criminal incidents. A lot of times those things can even come out through people that they interview on your behalf. Well, it's always important to keep your answers consistent, truthful, and frank. The worst case scenario is that they find a discrepancy somewhere along the process. It automatically turns into a Guideline E personal conduct. They feel that you've misrepresented intentionally, and it can be very difficult to overcome those difficulties. So a few examples come up, and I refer back to a polygraph quite a bit. So let's say you didn't list drug use on an SF-86 from 2018. They keep all of your SF-86s for several years, and they will compare as you undergo further reinvestigations, and especially if you are upgrading from, say, a secret clearance to a top secret, or if top secret then requires SCI access, which is secured compartmentalized information. In that sense, they go back and they will compare answers that you may have put on an SF-86 years ago. And then a common example on a statement of reasons that I've seen is, well, you're telling us this in 2023 that you've now used drugs, but you'd failed to report this in 2018 on your SF-86. At some point you misrepresented this to the government. it becomes a large issue, which can be difficult to get over. And I say that because with security clearance cases, your responses are sometimes very document driven, especially in other guideline cases. For a Guideline E, it's almost impossible to provide documents to show that you haven't lied or intentionally misrepresented information to the government. At that point, when they're analyzing a case, they're looking at the whole person concept, you as a person, really the reasonings you provide behind what happened, whether it was an honest mistake, an oversight, or whether it was an intentional misrepresentation. Now, if you want to move on to the next slide, Taylor. So this goes hand in hand. We've talked a bit about this already during our presentation today, but the importance of accurate reporting, that's where the number one issues start, and they just move forward from there. And we can leave that up for a few seconds while I'm talking about this. But, with all Guideline E cases that are, have disqualifying conditions, while they are difficult to mitigate, there are mitigating circumstances that can be argued to favorably adjudicate these cases. And some of those, going back to my example of failing to report past drug use, you could have had counsel from someone that advised you to not report something, and it may have been inaccurate information. You could show that you made an attempt to correct the issue before they addressed it with you. That's really the number one. If you realize you make a mistake on the SF-86, or, maybe you go back through and you're like, oh, I should have answered that question differently. Always try to go back and correct it. It's always better to say, I made a mistake, I need to correct this, and really whatever information you're sharing is going to be more favorably adjudicated than if they find out that there's been a discrepancy and you failed to correct it. And if they can show that you had knowledge, or they think you had knowledge of it, they're going to think that you intentionally misrepresented. The big thing is for the government with Guideline E, if they're looking at these circumstances as if you're trying to hide certain information by not disclosing it, that would then make you vulnerable potentially to exploitation, manipulation, or duress. So let's say you have a significant crime that was maybe a harmful act to someone, and you hide that. Their position is that information being released could, negatively impact you, and someone could use that against you. And so they do take it to that drastic circumstance, and when they review these cases, to have all the information out there on the table prevents any opportunity for vulnerability to any of the exploitation, manipulation, or duress that could potentially come from it. Let's move on to the next slide there, Taylor. So failure to self-report, I'll go through this. So it's important, even after you've been granted a clearance, specifically after you've been granted a clearance, you want to make sure that all of your information on the SF-86 is up to date and accurate, down to individuals that you are cohabitating with, your spouse, any foreign contacts. If you were to even accidentally, I've had individuals ingest illegal substances at potlucks, at parties. Even if it's something that's accidental, unintentional, it needs to be reported. Anytime there's anything that could come up where they can learn of information, for example, an arrest. A lot of individuals can misread that question and think that it's only a criminal charge or a criminal charge or a conviction. That's not the case. So whenever you have even an arrest or a criminal charge, even if it's dismissed or expunged, it's to be reported, and it needs to be reported quickly. Anytime there's a hospitalization for mental health concerns, anytime there's foreign travel, and if you have debts that go in collection or you file bankruptcy. So it's really important to get ahead of the potential issues, because all of those that I just mentioned fall under other guidelines of the 13 that the government considers at all times to determine whether or not someone's eligible. They typically will tack on Guideline E if the individual didn't report it in a quick manner, and they have to bring it to the individual's attention. So the government recently has been more effective in doing a continuous vetting program, which means they are consistently, periodically looking at credit reports, public records, criminal records. So these things ping. If you get arrested, it would ping. They find out about it, and it looks much worse and is much more difficult to overcome if it hasn't been already reported up to the security office. There's ways that we can assist in reporting, and we can definitely assist in, assisting with the SF-86 completion, to help clients really avoid these type of issues. And I think we can go on to the next slide there, Taylor. And lastly, just general conduct issues. As I mentioned earlier, it's an umbrella guideline. For example, if you use illegal substances, and I go back to this a lot because it's a prime example that we have, that we work with. And so they'll address the initial illegal drug use under Guideline H, but they'll also address it under criminal conduct and personal conduct, because ultimately they see illegal drug use as something that could affect your they see it as an unwillingness to abide by rules and regulations as it's against federal law. Same thing with finance. They see it as an unwillingness to pay your finances. Same thing with most of the other guidelines. It can definitely be thrown into an accompaniment of all the other 13 guidelines. I've seen it many occasions. It's usually not a reporting issue alone. It's tacked in with one of the other 13 guidelines. And so, like I said, of the 13, I think it is probably the most difficult to overcome because, as I mentioned, it's something that can't be heavily documented to show that you didn't deliberately omit, conceal, or hide information from the government. So, but it can be done. It's not impossible. There's plenty of mitigation that can be provided, but it's more important to get ahead of it and to accurately report everything to prevent it in the long run. So I think we're ready for questions. Taylor, I think we might have some in the chat.
Yes, there was one in the chat, and then I'm going to send you over some pre-submitted questions as well. If there are any additional questions for Brittany, please send them via the chat.
Perfect. And I see one. It's how far back should you report? So I always go by the guide of read the SF-86 with a magnifying glass carefully and slowly. There are some questions that go back 7 years, and there are some have you ever questions. And so if it falls within the time frame of the 7-year period or the have you ever, you want to make sure that it's reported on the SF-86. If it's something that just happened, there's not a particular timeline to, there's not an unwritten rule that says 2 weeks is good or a week is good. I would say as soon as possible, when something happens, I would self-report it and provide as much information regarding the circumstances as possible, just to get ahead of them potentially reaching out to you and addressing it with you. So while there's no specific timeline, the sooner the better. So it looks like another question is how to clear a JPAS record when claims are unsubstantiated and fully adjudicated. This is a little bit off topic, but there is a process that will probably be covered in a later session. But there is a process to appeal to the Department of Defense to correct the JPAS records and incidents that are entered by past employers regarding terminations and whatever else there may be. There's quite a bit of an appeal process there. Another question coming in is why failing a polygraph is considered a bad personal conduct. So a few things come up with polygraphs, and it can be something as so simple as your physicality, how you're, if you are, I guess, trying to withhold your breath or trying to withhold body movements. Those things can trigger a negative polygraph result. They can also tell if you're falsifying information. And so anytime that, they can tell that you're falsifying information and or trying to manipulate a polygraph response, that's definitely seen as an unwillingness to participate properly in a security clearance investigation. Is a polygraph administered for all SF-86 applications? No, it is position specific. Typically, it's top secret and higher, and it depends on the position and what level of classified material you would have access to. And that goes for all different agencies across the board. All right, well, it seems like those are all the questions for today. I appreciate everyone joining us. Like I said, Guideline E is definitely something to take of great concern when you're filling out the clearance application and while holding a security clearance, because it is, an important topic to an important topic to learn about and have knowledge of. So I appreciate everyone, and I look forward to presenting more presentations to you in the future. Thank you.